Hello.
Hello.
This is, episode 2 of our little new season, recording in this amazing studio. And it's very warm in here today.
It is very warm.
So,
absolutely.
Yeah. So this is kind of like a bit of a two-parter, isn't it? So we did the first part, which maybe some people would have already seen, to do with divorce and death and why it's important to have a will and have it done properly and all that good stuff. Now we're going to talk about, and it kind of follows on from that a bit, about children and what was to happen if you were to pass away, what happens with your children, who would look after them, and all that sort of thing. I'm going to sit here and ask you some questions, as with before. Hopefully you don't feel like you're being grilled. But, I think it's important that we ask kind of questions that maybe people are thinking about and would want to ask. And, so if we kick it off... So obviously in that first part we concentrated more about the sort of financial implications of death and divorce. So if we could look at the impact of these life events but on children.
Absolutely. And thank you once again for letting me talk about various things with the two of you.
Pleasure.
Peter, I think you'll agree with me that thankfully it's fairly rare that we get parents passing away with young children, which is good, and long may that continue, but that doesn't mean it doesn't happen, which is why when I sit down with a client with children, we make provision either within their will or otherwise that if anything should happen to them, provisions are put in place, that some safeguarding is done for those children, to make sure that someone's looking after them. So we'd commonly call that a guardian or a testamentary guardian, whatever terminology you want to use, but ultimately it's somebody that I trust as a parent to look after my children in the event of me passing away.
And is that the same thing? It's just got two different names, testamentary guardian and guardian.
Yeah, ultimately. Now, a testamentary guardian is somebody that you choose within your will, so your last will and testament. Yeah. But ultimately it's the same thing, Lucy. Okay. Now, the real issue, I suppose, that we're talking about today is how do we plan, or what considerations do we need to have in the event of divorce proceedings? And how might that affect if someone passes away at a time where I am splitting the relationship from my wife or from my partner, from the mother or father of my children? What things do I need to think about? What considerations should I have for my children and for the planning I put in place?
Yeah, I think that's absolutely right, and it's the wider sense of it as well. It's not just the current splitting, and it's much wider as well than simply divorce. It covers people who may be happily married, it covers people who are going through a separation, and it covers people who may have separated a long time ago and still have children that they're jointly parenting. I agree. It is reasonably rare to come across it in professional life, but it's not as uncommon as you think.
No.
I think the death of a parent for children in Britain, the last statistics were, I think, about 12,000 a year. So, whilst it's rare, it's not that rare. It could be something that people will come across over their working life, I would have thought. And for the vast majority of parents, the surviving parent is the one who will continue to hold what we know as parental responsibility. That's the right to have a say in and to control the major issues that affect the upbringing of children. And it will fall on them usually to be the ongoing parent to the child. But undoubtedly there will be circumstances where the surviving parent, for whatever reason, can't do that, is not willing to do that, is not capable of doing that. Or there may be other people in the family who feel that that's not the right thing and that they would be better placed to provide what's in the best interests of the children in those circumstances. So it's not always as straight and clear cut as that. And one of the things, Richard, that kind of helps in that process is if some thought has been given in advance to who will be the guardian and the testamentary guardian, rather than just doing it at a moment of crisis when people are emotionally, wrung out, to then try and come up with clear, cool decisions about what is in the best interests of children, it often creates a lot of competing interests with no clear pathway.
Absolutely, and I'll sit down with my clients and we'll talk about it, and 9 times out of 10 they're shocked that we're having that type of conversation, because they've come to me to make a will or to talk about their estate planning, and they assume that it's all about the assets that they have, the properties, the money, the investments, and where it's going to go. And they're more than happy to consider, you know, if these people aren't here, then the assets will go here, here, and here. So they've thought it through. But what they very rarely think about is, well, what happens if we both go and the children are minors? Who's going to look after them? And we find quite often that there is a split between the parents. And that might be because mum thinks that her siblings or parents are the right people to look after the children, whereas dad thinks, actually, no, I would prefer these people over here, because can't you remember what happened at the Christmas 4 years ago? And you know, a lot of the conversation, the time we spend with clients is letting them sort that issue out. Which is why it's really important, as you say, Peter, that people think about it now. They think about it at the point of making their will, or before, or at any point, but certainly before an issue arises where a snap decision must happen. The key thing for me is that they make a decision, because the risk is if they don't, then the decision will be taken off them. Either, as you say, another person with parental responsibility will step up and assume the role, which I or my wife may not have been happy with, or the state will step in and make that choice. And then it becomes a little bit of a fight between competing interests of different family members who may feel that they have the better claim. And I hate using that term because it feels like the children are an asset, but to some people, children are an asset, which is another issue in itself. But, you know, well, I'm better placed to look after those children. We then have the horrible conversation of, well, you may feel you're better, you may feel that your parents are better to look after your children, but they're based in Devon whilst you're based in Leamington. You have to pull them away from their life, from their friends, from their school, from their surroundings.
So it's thinking about the practicalities as well.
It's the practicalities. It's the who, and it's the what if, but it's also the practicalities of it. I've had examples before where people have nominated guardians that live in different countries. Now that in itself has a whole different issue, but you know, that is pulling up the roots of a 4, 5, 6-year-old and saying you're going to change your entire life. So it's a really, really interesting but important decision. I would argue more important than where your assets go. You know, who are going to look after these children?
I think that's right. I mean, the effect of a testamentary guardian is to grant that person parental responsibility for the child as at the date that the death occurs.
I was just going to say, what happens if you've got a testamentary guardian and a surviving parent with parental responsibility? What would happen in that sort of scenario?
I think you'd need to see if they could act together to start with, to see if they could agree the arrangements in advance, you know, and pull together a plan. My experience, whether parents are alive or not, is a parenting plan is a very, very good idea. Parenting plans tend to cover not just the day-to-day living, but things about education. What will you do on consents to medical treatment? What
religion,
will you do for religion upbringing? All those things could be covered and need to be thought through to make sure that it's not just about the narrowness of parenting, it's the wider implications for extended family, for example, maintaining contact with grandparents and maintaining contact with people who are important in the children's lives. So I think a parenting plan is quite important. If a testamentary guardian is appointed and there is somebody else with parental responsibility, they should be able to try and work those through, a surviving parent, for example. If that's a dispute, then ultimately the court can decide that dispute. They can decide under the Children Act who is in the best interest of the children, should look after the children and to provide for and meet their parental responsibility needs. And in any application under the Children Act, the welfare of the children is the paramount concern. I think it might surprise quite a lot of people that there's no presumption at all that a child must live with a biological parent following the death of the other parent. That presumption doesn't exist. You're looking at it purely through the eyes of the children, what's best for them. And so, as you say, if a testamentary guardian's been appointed, and it's entirely impractical because they live on the other side of the world, and there may be other members of the family who feel it's right to step forward with permission of the court if necessary to say, actually, it's better if they stay with me in this environment.
Absolutely, and the key thing there, on top of whether or not they are suitable, or another consideration when they're suitable, is have you spoken to them?
Yeah.
So that was something I was going to ask, because obviously you can't just, I would imagine, you can't just say, I want to appoint Joe Bloggs on the street.
Well, you can.
Need to have a but you would want to have a conversation with them, because that is a very, very serious thing to undertake to do.
So if I was to make my will now, I could nominate you, Lucy, to be the guardian of my children in the absence of my wife. Now, if I hadn't spoken to you about it and I pass away,
that might come as a bit of a shock.
It might do. So you get a knock on the door and there's two little children standing there with all their possessions. Right, Lucy, here you go. Now, the risk there is that you say no, and you'd be well within your rights to say no. And then there is, once again, this issue of, well, now there's nobody. You know, hopefully there'd be other family members that would step up and look after them, but there might not be. So then what happens next? Well, the state intervenes. Now, the last thing I would want is for my children to be moved into state foster care. So that's why good planning is important. But equally, I need to make sure that the people I appoint are suitable, financially stable, and able to look after it. If I appoint my sister, who's already got several children, is she going to want two more added onto the mix? Is the housing suitable for her? Is she going to need financial redress from my executors? Which is another sort of implication here. And that in itself is a question. If I'm appointing a person as a guardian, do I appoint the same people that are my executors? Now, I know we're going off on a tangent here, but we get it all the time. I trust you, Lucy. I trust you. So I'm going to appoint you as my executor. That's the person that will look at my will and make sure everything gets collected in and goes to my children, because that's what my will says. I also appoint you as my guardian. So now you're looking after the interests of my children and you have access to all my money. The question there is, do I trust that you would be able to separate your own finances and the finances of my children? Or will you be tempted as guardian to utilise some of the money that you have control of to look after your own needs? So we regularly advise clients on, do we keep those two roles separate? The people looking after the money for the kids and the people that look after the kids themselves.
And I think that could almost be a whole separate podcast, couldn't it? You know, how you go about executors and appointing them and making sure you're picking the right person. That's a really interesting topic by itself. But how does one actually go about appointing a guardian? So,
a couple of ways. A will. That's the best way, in my opinion. Pop it into your will. Go seek some advice. Now, we spoke on a previous podcast, and the private client team have got podcasts as well about wills and the different types and the benefits of making them. But it is as simple as a clause within your will that says, I trust that person over there to look after my kids. Once you've done that, if the will is executed, it's made correctly, then you should be fine. Subject to all the things that we just spoke about. Like I say, Lucy, you might not be happy that you're the person appointed. You're not, by the way, but just so you know.
I've gathered as much.
Yet. That was definitely a no there. There was a nervous laugh and a no, Peter. But a will is the right way to do it. The other way would be in a letter of wishes, or a note of some sort saying, if I was to pass, these are the people I trust. Now, I would argue a bit of both. So something within the will that says, I trust you, but equally guidance to your executors, to your guardians, if I was still here, if I was still looking after my children until they're 18, this is what I would do. Yeah. This is the education I'd give them, the trips I would take them on. These are the things I would want you to insist on, the discipline that I would instill, these kind of things. Because otherwise you might find that the people that you trust to look after the kids don't manage your children, nurture your children in the way that you would want them to.
I think that's really important, a really important point. I think there is this distinction between appointing the testamentary guardian, which grants parental responsibility in the event of the death, a legal definition, which gives rights under law, and letter of wishes, which doesn't give the rights under law.
Absolutely.
But which you can use together with the testamentary guardianship to be able to say, these are the things that I would like for my children. These are the things that are important to me. And that could be religious upbringing, very often. A whole range of things could be put in a letter of wishes, which whoever's responsible doesn't have to follow. But you're doing in advance is providing the roadmap to say this is, in some ways, it's an ideal worldview of this is how I would want my children to be brought up. And it's really helpful, even if it's not the testamentary guardian who's appointed. So whilst it helps them directly in the same document, if it's somebody else who ultimately is appointed for whatever reason, a grandparent, a step parent that may not have been thought about at the time, they will still have a letter of wishes, which will still set out exactly what they think, the way they want their child to be raised. So I think they're two very distinct, separate, complementary documents, and the only way you can get them done is by having kind of the formal planning that Richard's just outlined. But I would see a letter of wishes, if I was going to be able to do it, as really important, actually, because I think it helps people to say, right, this is the roadmap, both for my executors as well, financially. You know, if the children go to university, these are the things which I would like to happen. If they get to 17 are interested in buying a car, these are the things financially I would like to happen. And then to deal with the bigger ticket issues, as you say, religions or medical treatments or whatever.
Football team, of course, is really important.
That is essential, but I think that's a matter for another podcast on another day.
A whole separate show.
Because you often get situations, I think, where people come in, if an event happens, a parent dies, you have a testamentary guardian, but you may well have step parents who have been brought in, the grandparents, etc., depending upon where they are at stage in life, who want to share that role and who want to be part of it. And it's incredibly important if children are going to maintain dynamic relationships with all their extended family in that scenario, that conversation takes place, and ultimately somebody's got to have parental responsibility for the children. That's essential in the management of their upbringing.
Is there any kind of final thoughts on this topic that you might have, Richard?
I would urge everybody with children, if they haven't already, to consider what might happen in the worst case scenario. And it always surprises me the amount of people that have children that haven't given thought to that. And I think it stems back to the idea that nothing bad will ever happen. It's always these horrible things happen to other people. But the reality is that we just don't know. And if we don't have planning in place, then the reality is that something that they didn't want to happen might happen. So spend the time now. It's the best thing you can do for your kids, is to spend the time and consider how they will live their lives when you're no longer here. In the knowledge, I hope, that nothing should happen to you and before they're 18. But it's best to be safe than sorry.
I think what's interesting as well is that a lot of people might think that godparents take that role. Within certain communities, people might think that godparents have that role if anything was to happen to the parents of these children, but obviously that's not the case.
Absolutely not. No, it's not the case. In law, it's not the case.
And you need somebody in law who's going to have that parental responsibility. It's a legal right, which enables then all the important things for that child to happen. That's really, really important.
And it could be that if they've not made provision, but they have nominated godparents, that they are the ones that jump up and down after death and say, I'm the right person for the role. But it's a legal process. It's an arduous
it
legally.
Has to take its course anyway.
Absolutely,
I think for me, what Richard's describing is it provides a framework that people can rely on in the event that this catastrophic event happens. it is relatively rare, but it does happen to 12,000 people during the course of a year. And what you need is some form of framework to hold it all up. That might not be the ultimate outcome. There may be some times where you have to think it through, get over the emotion, work out different things for different children sometimes. We've talked about blended families, stepchildren. There are whole different arrangements. But it provides the framework that props that up in the short term.
Yeah.
And I think you can then work it through, unravel it, deal with what's required without having to rush into an immediate relationship. Following the death of a parent, you don't want to be, the following Monday, applying to court on an emergency basis for somebody to be granted parental responsibility, or God forbid the death of both parents in that circumstance. And I think people should always keep, where they're having these discussions within their family, if they're having the discussions generally about the welfare of children, that the Children Act itself and some well-established principles put the children at the heart of all of that, over and above the concerns of other individuals. And that's what all this is determined, is about. It's about getting the right outcome for them.
I think too many people assume that the right thing will happen at the right time. And that's just not the case.
No.
People assume that parents, grandparents, friends, siblings will take custody, but for the reasons we've discussed, they might not be able to. So you've got to plan for it.
You can almost guarantee, I can guarantee you that it won't happen as you expect it to happen, that there will be, unintended consequences. And as I say, having some form of framework helps with that enormously. I've seen it a number of times actually over the last 30 years of my career. I've seen children who have been left without parents, and I've seen children who've been left with one parent who's wholly unsuitable. And we've had to work incredibly hard within the family to achieve the right outcome and protection for those children. And I've looked after the children themselves in some of those circumstances. So don't underestimate it. They're a big responsibility. You take that on when you have a family. And it's a relatively straightforward thing to do as long as you've thought it through.
You just need to have an open and honest conversation with yourself, with your partner, and with your loved ones.
Yeah, I agree.
That's the key.
I agree.
Well, thank you both very much.
That's
been very interesting, and really, really, really interesting topic to be able to discuss. So that's really good. As always, we always finish these podcasts off with saying that anyone can contact us if they ever need any help whatsoever. We'll be there for them, and we're more than happy to help where we can. So you can visit the website, fill out a form on there, and we can give them a call, or reach out to us directly.
That's great. Thank you.
Thank you.